Epic judgment revealing the full verdict. Uncle Phon imprisoned for 20 years in Nong Chompoo's case, dismissing the charges against Aunt Taen. At 10 a.m. on December 20, 2023, Mukdahan Provincial Court read the judgment in the black case number A1013-2021 between the Mukdahan Provincial Prosecutor, the plaintiff Miss Sitri Wangsricha, co-plaintiff number 1, Mr. Anamai Wangsricha, co-plaintiff no. 2, and Mr. Chaiphon Wipha, the defendant number 1, and NS Somporn Lap Pho, the second defendant. Together with the two plaintiffs, filed a request for civil compensation. The plaintiff sued that on May 11, 2020, the second defendant took away Miss Orawan Chompoo Wangsricha, aged 3 years and under 15 years of age, from the co-plaintiffs, both mother and father, without cause. Appropriate. Between 11 and 13 May 2020, the first defendant, with intent to kill, abandoned Miss Orawan, who was not yet 9 years old, at Khao Phu Lek Phi alone without food or drinking water. In order for Miss Orawan to be separated from herself in a way that leaves the child without a caretaker. It caused the death of Orawan girl, and between 13 and 14 May 2020. After the deceased had died before the autopsy was completed, the two defendants moved the body of the deceased together and took off his clothes and pants to make the officer or the person who found the body understand that the deceased was sexually abused and beaten to death in a way that is likely to cause the autopsy of the deceased or the results of the case has changed. The case has a problem and must be determined. Did the two defendants commit the crime as charged or not? It is seen that the area where the body of the deceased Miss Orawan was found was on Phu Lek Phi Mountain. It is approximately 1.5 kilometers from the place where the deceased was last seen and is a steep slope. In addition, in the said area, several strands of the deceased's hair were found to have been cut with a sharp object. Therefore, it is believed that the deceased, who was only 3 years old, was unable to walk up to the area, found a corpse and used a sharp object to cut off their own hair, but the culprit had to take the deceased away. The next problem must be to determine whether the first defendant is the criminal or not. It is seen that firstly, on the day of the incident at approximately 9 a.m., the deceased was playing in front of the house and there was a girl, A, the deceased's older sister, lying nearby playing with a mobile phone. Until around 9:50 a.m. Girl A looked for the deceased and didn't see her, so she went out to look for her. Therefore, the deceased must have disappeared before that time. Girl A testified that she did not hear the deceased cry at all. She believed that the culprit who took her the deceased must be a relative or close person in the village that the deceased knows well. Because the deceased would cry if held by a stranger, the official police then investigated the group of 14 people, divided into 12 relatives and 2 close friends, and found that 13 people had clear evidence confirming their address or location from their mobile phones. Except for the first defendant, who could not confirm his exact address at the time the deceased disappeared. Secondly, defendant number 1 gave many suspicious statements. For example, defendant number 1 testified to the police investigating officer that on the day of the incident, defendant number 1 had an appointment to pick up a monk at Tham Phu Phaak Temple. While traveling to the temple, the second defendant telephoned to inform the first defendant that the deceased had disappeared. But the families of the two defendants had only one mobile phone with the second defendant, so it was impossible for the second defendant to call and report the matter to the first defendant. Moreover, Fra B, who is also staying at Tham Phu Phaak Temple, confirmed this. That day, at around 10 a.m., the first defendant traveled to the temple and said to the monk that his grandchild disappeared and he almost didn't go to send him off to the monk. Even at that time, the first defendant, who did not have a mobile phone with him, must not have known the reason the deceased disappeared. Thirdly, the prosecution's witnesses, Mr. W and Mrs. P, testified during the investigation that witnesses saw defendant number 1 near the rubber plantation, which was a walkway that could reach the spot where the deceased disappeared. During the time when the criminal committed the crime while this matter was being investigated, the first defendant tried to talk to Mr. W, having Mr. W tell the police officer that Mr. W met the first defendant at 7 a.m., not during the time of the incident. In order to prevent the officer from the police suspect the first defendant if the first defendant did not commit the crime. Why must one speak in such a manner to a witness giving evidence to a police officer? According to the facts that he saw even later, during the examination of witnesses, Mrs. P would testify that he did not see the first defendant in the rubber plantation area, but this was a reversal of his statement more than 2 years after the incident, which may have been done to help the first defendant. Her testimony during the investigation P therefore has more reliable weight. Lastly, after the police officers suspected that the first defendant was a criminal, they entered and searched the car. The first defendant found 16 strands of hair and other evidence. The results of the scientific examination combined with the testimony of an expert witness revealed that one hair that fell into the third defendant's car had the same angle of cut, cross-section, and side surface as the 2 hairs of the deceased that were recovered. From the area where the deceased's body was found, all 3 strands of hair were cut at the same time with the same sharp, hard object. It is believed that the first defendant was the one who used a sharp, hard object to cut the deceased's hair. But because the hair was so small, the defendant did not notice that one of the deceased's hairs had fallen into his car. In this regard, the investigation of the police officers in this case did not focus on the first defendant from the beginning, but it was a result of gathering evidence and making assumptions in a step-by-step manner as determined above. It did not appear that any person involved had a cause for anger or an incentive to slander the 2 defendants. So they believed that the first defendant was the criminal who took the deceased up to the mountain. Khao Phu Lek Phi, the next problem must be diagnosed. While taking the deceased up to Phu Lek Phi mountain, did defendant number 1 know that the deceased has passed away, or is still alive? It is seen that the first defendant had no reason to be angry with the 2 co-plaintiffs or the deceased before. Therefore, it is not believed that the first defendant had the intent to kill or to abandon the deceased. Along with the report of the examination of the deceased's corpse, it was found that there were bruises under the scalp, forehead area. There were blotches on the left side and the back of the neck, so it may have been the case that the deceased was unconscious. As for the first defendant, he didn't check carefully and took the deceased and left him on Phu Lek Phi mountain. The first defendant's action was a crime of negligence causing the death of another person. The plaintiff alleges that the two defendants worked together to move the body. It was seen that from the day after the incident until the day the plaintiff's body was found, there were no witnesses who testified that they had seen both defendants. 2 Up the Phu Lek Phi Mountain. Although the results of the examination of 3 hairs from the area where the deceased's body was found had mtDNA matching that of the second defendant, the mtDNA test could not be used to identify the person. It can only be determined that it is the hair of a person in the same maternal line as the deceased. Therefore, the said hair does not have to belong to the second defendant alone. It is seen that the benefit of the doubt should be given to both defendants in this charge. The court ruled that the first defendant was guilty under the Criminal Code, sections 251, 317, first paragraph, for acting negligently causing the death of another person, and was sentenced to 10 years imprisonment for taking a child under 15 years of age away from his parents without cause. Reasonable imprisonment for 10 years. Other charges for defendant No. 1 to be dismissed and charges against the plaintiff for defendant number 2 to be dismissed and defendant number 1 to pay civil compensation to both co-plaintiffs. In this case, the Chief Justice of Region 4 and the Chief Judge of the Mukdahan Provincial Court examine the documents and make a dissenting opinion on the evidence of the plaintiff and the 2 co-plaintiffs that there is reasonable doubt. The benefit of the doubt must be given to the first defendant and it should be judged to dismiss the case. Therefore, it must be included in the expression. According to the Constitution of the Court of Justice, Section 11, 1.